child line has to be that filter of what we're doing here. Like, I don't understand why, if we're telling the public to report these crimes, and even if they're mandated reporters, okay, to report these crimes, that has to go to one central location to then be dispersed from there to where it should go. Like, I don't understand why, you know, in this instance, you're going to call the DA's office. In this instance, you're going to call this person. In this instance, it is too confusing. You know what I mean? And we're arguing over definitions here, which are already definitions somewhere else. Like, I don't understand why we're trying to reinvent the wheel. Let me tell you right now, Children and Youth Services, at 2 o'clock in the morning, out in the middle of nowhere, they're going to get confused over this. That's what's going to happen. I mean, we got to keep it as simple as possible, because the people who are they're not going to be here at 11:10 in the morning, sitting comfortable trying to define what bodily injury is, or trying to figure out what is bodily injury.
Well, except Trooper, and that's one of the problems with Jackie missed some of the discussion we had this morning on some of these subjects. You've missed our prior deliberations and the testimony we've taken. One of the problems is that the present definition of what injury is required for child abuse has certainly allowed the Commonwealth Court to subvert a number of instances where I think we're all satisfied that the kid got abused, but not the Commonwealth Court isn't binding. So I will tell you, we're lowering the standard, and that standard's about as simple as it gets. It's simpler than the standard that exists now.
You know,
Okay?
I understand it, but like everybody's talking about, like, putting all of this litany of like defining it, like fractures and broken bones and this and that. I think that comes down to the training issue more than it comes down to putting it in legislation. You know, you have to get out there, and we have to set a standard of training these individuals. We have to set a standard of training the individuals at Child Line who are answering that phone. You know, they have to meet this standard so they know what the definition of bodily injury is. You know, and they know what is or isn't bodily injury. I think that's where the shortfall here is. I don't think the shortfall is giving, you know, same thing with our guys. You know, I mean, you give, love the Pennsylvania State Police. I'm going to preface this statement with that. If you give our guys this list, they're going to go, it's not on the list. We're good. And that's what, you know what I mean? And that's what's going to happen. People are going to focus on these things here, and that's it.
But what they're suggesting is that all calls go to Childline, and Childline then decide when law enforcement gets the referral.
But I just need to get this in my head. All calls by mandated reporters?
I thought we were talking last time about a public service education, educating the public to call Childline. Yeah, I thought that's what the direction we were headed was. In addition to mandated reporters, we're talking about people in general calling Childline.
We need to clarify.
They do now.
Yeah, I mean, right, but we also acknowledge that right now, we don't have the resources to address all the calls we're getting now, let alone broadening the definition, and now expecting Childline folks that are answering the phone to be making several decisions on behalf of law enforcement.
They are now.
They are now.
Most people today have no
But that's
idea
the problem,
what the
isn't it?
definition
That's part of the problem.
is.
No, and what we talked about earlier, though, is we're sending, when we get those, and our conversation was, we get the call, and it meets definition. So right now, there's harm to a child. We look at that and say, okay, is it a perpetrator? Is it a parent? Is it a person responsible for a child's welfare? Is it one of these? If the answer to any one of those questions is yes, then we send it to the County Children and Youth Agency. Based on the allegations, then they're required under 6340A10 to notify local district attorney and the law enforcement official responsible for investigation. If the answer to that question is no, this doesn't meet the definition of perpetrator, we refer all of those right now to the district attorney. So we're sending those to the DA now. What we talked about this morning was sending them to the DA and a local law enforcement agency at the same time.
Immediately.
So we're doing that, we're already doing that, and we're making those decisions. So we made over 8,000 referrals last year, or 33,000 actually, that went that way. And so we're getting those referrals out. We're not saying, oh, we don't think this meets the definition. If somebody makes an allegation, we're sending it. If it doesn't meet our definition of perpetrator, we're giving it to law enforcement. So we're not even doing like a lot of triage or screening, but we're asking who did it. and then sending.
But Jackie's concern is that we're going further with the statute and creating some general duty on everybody. If you see a crime against a child, you don't call 911, you call Childline, and that's certainly not the direction that the task force,
Right, and
that's not
well,
my
I
sense of the direction
I
of the task
thought
force.
that last time we were even talking about like public service announcements, and we weren't just limiting that to mandated reporters. We were
That's
talking about changing the concept of how people see child abuse in the community at large. So, I mean, maybe I need some clarification on what, we're suggesting in terms of that too. But I know several times that folks on the task force have said during hearings, they want to see resources allocated for marketing towards reporting child abuse. So,
And I think you are seeing more and more of that. We're certainly hearing about more and more groups that want to do that, but I don't know that that's really going to, right now, if you suspect abuse, anybody can pick up the phone and do whatever. I think the average person on the street, if they see something, they're probably gonna call the police, like they would anything else, if they're going to pick up the phone. Mandated reporters must contact child. I'm not thinking that the volume, and I could be very wrong, but I'm not thinking that the volume will be that much greater than what we have today. People that are gonna call today and see something, they call. They call somebody, they call Childline, they call somebody.
But what I'm hearing Jackie say is we're
She thinks something
concerned
more.
about a general recommendation from the task force that the central number be the repository that
And
anybody
I think it
calls.
should be, because I think it's.
I
You mean
think-
don't
I think
call
we need law
911,
enforcement
call
to seriously
Childline if you're
consider
not mandated
that,
reporter?
and even when
They
we're
would
going to
not
make
know.
it
What? I'm
testify
sorry.
before us.
What,
Well,
Mayor?
I mean,
Well,
seriously consider the
but-
impact of that.
Let me note that, and I think this was discussed before you came in, on the 20th, we're going to hear from Childline, we're going to have a hearing,
Right.
so that,
You should do it.
that is an appropriate discussion for that time to some degree, and we certainly do need to make clear what the procedures are going to be. I think the idea that Childline won't be able to handle the volume is something, I don't want to quote Robert Kennedy, but, it's like some people say it can't be done, or whatever that quote was about it, I say, why not?
Right.
We want to be in a position of saying, damn it, at least 12 months from now, Childline's going to handle whatever it needs
That's
to
what.
handle. But I agree with you, we need to have a separate policy determination, and I don't think we will want to be recommending that, to anticipate that determination, that if you see a crime against a child, call Childline. If you see a crime, call 911.
Right.
But if you're a mandated reporter, the mandated reporter is going to have to call Childline, because that's the obligation
It
replacing.
doesn't have a duty to do a dual report.
But you're saying mandated reporters do have a duty to do a report.
Yeah.
No,
Uh,
they don't. No, they have to call Childline, and then Childline is required to notify the county and law enforcement.
Yeah, but that's, we get away
Okay.
from.
Your
If
county,
mandated reporters don't know who to report to, we have a problem, okay? So we have to keep it as simple as possible. Just, if you say, call this number, and then if you're concerned about child abuse, call this number. For everybody, you're good. That's what we have to do, I think. And that can go to Childline. If we have within Childline an ability to get it immediately to the police, and get it to the DA, and get it to
Right.
child welfare, and know where it has to go. But there should be no wrong door. So if you call 911, the police need a mechanism to know that if it's a child abuse issue and it's in the home, that they get child welfare involved immediately. So, you don't want to prohibit, but for people like Rachel, whose hospital makes her crazy, like, she just has to say, no, I just call one number and then it gets done.
I think people call 911 because it's easy to remember. Childline,
Yeah.
1-800. So I get if you just had a 3-digit number, you get a lot of the appropriate calls to Childline simply because people remember the number. I mean, 911, that's what I would call too,
Okay.
because it's 3 digits.
I'll tell you what,
But I
Let's-
think in the crimes code, there's a specific responsibility upon medical practitioners to report if someone is the victim of a crime, and that's what you're talking, that's
That's
what
what
your
you're saying.
solicitor,
But it has
that's
to
what
be
your
divided
solicitor is
every
advising
weapon.
you.
I'm telling you, there's a loophole in that one.
Well, it says, it doesn't say deadly weapon, it says instrumentality.
It does, yeah.
I'm looking
Weapon.
I'll look for the language, but I just looked it up for our hospital,
Okay, guys, let's
No?
herd this, if you can find that section, it'd be interesting. Let's herd this back to, or we will walk out of here, and I think somebody said 6 o'clock going to, God help us. Well, we'll see.
We lose a lot of people at 3:30, so.
We'll see how that goes. At any rate, we won't have gotten anything done.
Yes, so,
The floor is yours.
okay. I think part of where we're getting led astray here is we have to focus on what we're doing. And right now, we're defining a term. And what the focus needs to be on is, what do you want child abuse to be? How you use it comes into the other areas of the statute, which is why I think you want to take perpetrator or caretaker out of this definition, because all you want to describe here is the behavior that is injurious to a child, whatever form it takes. And then elsewhere, how you define caretaker, and how you say, this is a caretaker's responsibilities, or this is the mandated reporter's responsibilities, this is DPW's responsibilities, is where you refine what you do with that definition of child abuse. But your definition itself, you want, obviously this is not the most artful version, but if you take your table and what Jason has brought and what we've done, and generalize some of that stuff, and you can say, okay, you've got 4 types of child abuse: physical, imminent risk, sexual, emotional, mental. And then you define those 4 kinds of injuries, however you want to define them. Then you take that definition and and we can say, okay, this is bodily injury, this is one form, and these are some general factors you should be looking at. We can even say DPW can further define these lists and revise them over time. This is an emotional injury. Here are the factors you look at to determine if it's an emotional injury. And then when you look into your mandated reporter, when you look into how you define child protective services and general protective services, that's where you put modifiers on that definition of child abuse and say, in this instance, we're looking at child abuse only as it applies to these particular people. And here we're looking at child abuse only as it applies to this particular instance. But your actual definition of child abuse, you want fairly straightforward and say, all right, these are the ways we define child abuse, and these are the parameters that you look at to determine if there's child abuse. And so we're looking at it almost in a vacuum, and that's part of the hard part of defining terms. But I think that's what we want to do. I think that was Dave's point, trying to get perpetrator out of there.
Well, and let me just propose something. We've so far avoided voting altogether, in part because in my ideal world, we've got a piece of paper in front of us that we're concretely voting on. Let me try something. I'm going to move that the core definition of child abuse that we're recommending to the legislature is the simple assault definition: impairment of physical condition or substantial pain. Now, that's a significant departure downward, as I understand things. We're including more conduct than presently is included. Well, we've had enough discussion. I won't discuss it. With the idea that there are going to be additional language which bear on deciding whether that is actionable, either in the child protective or actionable in the child protective services system. That's right. Criminal, separate deal. Criminal, you can have a simple assault on a kid 2 years old. I move that be the core definition, and if it is done intentionally or recklessly, and that we then, in a minute, get to how we use these other lists in order to shed light on it, but that be the core definition.
Second, if you'll accept a friendly amendment,
Okay.
because if it's just bodily injury, you can have more serious, I mean, it's how you
It can
define
go
it,
up from
so-
there.
Right.
Yeah, absolutely.
And that's, if you, that's kind of what we, the solicitors try to do, if you look at that.
Yeah, I'm
So I
not
would second
excluding
You're setting a-
going up, I'm setting a floor, which is considerably lower than the floor is in the definitions presently. It's been moved and seconded, but I see the hands of all those in favor. Okay.
Sorry, I know,
Impairment,
it's just
yeah.
a simple definition,
In
please.
the basic definition of the abuse of physical abuse of a child, I mean, we've got all those other categories. Impairment of physical condition or substantial pain, the causation of an impairment of the physical condition of the child, which is very broad and amorphous, or the causation of substantial pain to that child.
And that is consistent with the simple assault definition in the crime
That's-
code.
that's-
You take,
If
leave
you
out
just-
the whole list, forget the list.
Forget the
list.
list.
Forget
We're
the
going, I
list.
have an idea that we get to the list, but for the purposes of this
Permanent
list,
impairment of physical
the-
condition or substantial
the,
pain.
the biggest, and as I see it, the biggest question I'm posing, and gets to some of the points that Jackie was raising, we're now including more conduct than we did before. My objective in coming up with this is sort of, is tries to be kid-centered. Hey, if I turn to Mary and whap her, give a good one, if I just give her a shove, that's harassment, but if, you know, if I raise a bruise on her arm, I'm committing a simple assault. I have committed a misdemeanor, whether it gets dealt with it, you know, there's, or as something more simpler, but, you know, and I'm saying if I do that to an adult, if I do it to a kid, yes,
I don't want to muddy the water, but we talked a little bit about payment. Who is that to be substantiated by the person themselves or confirmed by a doctor? In other words, it's different that a 16, 17, oh, it hurts like hell, and there's nothing there, as opposed to, yes, there is something internally wrong.
and that's a proof issue, and that's sort of why I headed for simple assault. You've always got that issue. You know, I give Mary a shove, and she falls on the floor and is writhing in agony. You know, that's for a finder of fact ultimately. I know the issue that you
But
have
that
to
gets
deal
into
with.
the earlier issue you raised, which is very important.
And that's why we work backwards from that then in terms of, what's the state of mind? You have to do it intentionally or recklessly. And why I envision these lists, and it's been great that Yvonne drafted this. I envision those lists being used in a little bit different way. But first, we need to be systematic. First, is that an acceptable core definition for what we're going to look at, or obviously worse than that, but are we comfortable moving down to impairment of physical condition or substantial pain as sort of the floor of what happens to a kid that we're considering that child abuse?
That's your motion, I second it, I would just direct, is whoever wants to look at it, the Crimes Code, Title 18, 2301, their definitions, which is the language you just cited, for bodily injury, and we just have one definition, bodily injury, which incorporates that definition, but also incorporate the Crimes Code serious bodily injury into our definition of bodily injury. So they're not two definitions, and makes the language later on when we draft much more simplistic, we just say bodily injury.
I have to oppose slightly, I'm sorry. You didn't take the vote yet.
Right? Well, this is the time for discussion.
I still worry that substantial pain is as subjective as serious pain was. And Rachel and I can give you examples of kids happily running around the room who were, you know, choked or strangled, or who are beaten and say, it doesn't really hurt that much, or it didn't really hurt. And it's still so subjective, and if we're really stepping back and trying to define child abuse in a simple, meaningful way, I
then that would be, it would still be considered bodily injury, even if you as a doctor couldn't say he was suffering substantial pain. You know, he's running around the exam room, you would still be able to meet bodily injury definition because his bodily function was impaired in some way, as long as you can articulate what the impairment was.
What was the impairment? He can't, what if he can't sit down? What if his arms are completely full of welts, but he could sit down?
And he could use his
Or
arms.
he could use his arms. So where's the impairment? I mean, there are so many, and the choking, where was the impairment? He
Well-
didn't pass out. Where was the impairment?
Well, isn't the impairment just the obstruction of his airway, even if it's momentarily? I mean, I don't,
No,
How about a baby slapped across the face?
that's a perfect example. Perfect example. That doesn't mean any of those
Doesn't
definitions,
mean any
but
of
it's
it.
abuse.
Well,
That's
I
why we
would,
make
if
a
you
laundry
slap
list
me
that
across
says
the
slap.
face,
That's right,
I'm
that's what I'm
thinking
saying, that's what
my
laundry list
physical
is.
condition is impaired. If there's
Not,
enough,
not according to Pennsylvania.
No.
It's not
Well-
well, then maybe we need to add to the
Well,
definition and not just
this,
accept what the crimes code uses. Maybe we need to work on that language.
One of the
to-
issues, the crimes code shouldn't equal, I mean, it's what we say a lot in child, not every case that is child abuse is a crime.
no,
Right?
no, no.
So I would
Right.
argue, a child being slapped across the face and leaving a mark is child abuse. Do I want someone to prosecute it? Maybe not. Do you know what I'm saying?
Sure.
Because it doesn't really meet some of this bodily, but it's child abuse. And so it's not that we just want it to exactly equal. You know what I'm saying? I think it's not exactly the same.
That's how you get the substantial, I mean, that's your catch-all, is a substantial pain, right?
But how does it
But no,
benefit, but judges
can't
over and
define
over
it.
say, how do you know
That's
the
the
infant suffered pain?
Plus,
How can you quantify pain to an
Or the
infant?
child
All right,
says
well,
it hurt.
Or
now,
the child says it doesn't, it's on both extremes of the age, of the
Okay.
child age spectrum.
I will withdraw my motion. I'm assuming I'm not getting enough votes. Okay. Now, where we go from there, I would suggest you're going to need a general, something general. You would propose, and I'm happy to entertain a motion from either or both of the doctors simultaneously, or I'm going to keep talking if you don't come up with something. You would propose that in addition to, or maybe in substitute for, although I'll tell you, I don't think it'll work in substitute, that we have a specific list of forms of conduct that are going to constitute child abuse. Yes?
I want to
Yep.
step back for a second. If I read what Yvonne wrote, the first, on page 6, okay? You know, my problem is that I would like, if somebody says to me in the hospital, how does Pennsylvania define child abuse? I'd like to spew out a sentence. I'd like to memorize the sentence and say that's child abuse. But I'm having a hard time because there are 5 parts to the definition, okay?
Yeah.
So, and I wonder if I can think about condensing that. But if we think about physical abuse, maybe it's not so bad because it says, any recent act or failure to act that is, and I would actually do intentional or reckless, because intentional to me is like the first one, or that causes, attempts to cause, and that's where I think maybe we're okay, or substantially contributes to bodily injury. So if you attempt to cause, okay, substantial pain, but you haven't caused it, but the kid doesn't say it, but you attempt to cause, then through unjustified force, that seems like reasonable. I mean, that seems reasonable. Rachel, does that seem reasonable to you?
I guess, I think you have to define.
No, I'm sorry. Yes, because you, well, the problem I have with bodily injury is that there has to be substantial pain. But if you.
No, it's one or the other. Impairment of physical condition
No,
or
because-
substantial pain.
No, because in the definition that Yvonne wrote, you can attempt to cause bodily injury. You don't have to cause bodily injury. You can attempt to cause bodily injury. And that is an out.
But what the
No,
chair
no,
is saying, you don't need to have all the factors. Substantial pain is just one of them. You don't have to have impairment as well. It's an or.
Well-
What if you have neither? What if you
Oh,
have
oh, okay, you see, here you go. We're headed in the same direction.
Right.
An attempt is actually very hard to prove. My prosecutors, all the time, charge attempted murder.
Right.
Hardest charge in the world. It's easier to prove murder.
Right.
Attempted murder means, well, let's just, for attempt, I have to intend to cause the specific result in order for it to be an attempt. So we are now definitely, we're even further away from, well, he took this gesture, at least if you got the kid with the palm print on their cheek.
But that's your evidence of intent, in my mind. That's,
Well-
that is what?
Attempt to do what?
Cause bodily harm. Okay, so let's take our baby with the slap mark on its face, okay?
That's it, no other injury.
No other injuries. We have a baby with a slap mark on its face, okay? It does, we can't say that it caused substantial pain, because maybe it did, probably did, but maybe it didn't. It doesn't impair the baby's ability to suck or drink or do anything, so there's no impairment of any organ. But you can say that it's child abuse because the fact that you see this slap mark on the hand is evidence that the parent attempted to cause bodily injury. Like,
No.
is,
I don't
no?
think it's possible.
No.
That's not what the law.
I think if we
Well,
go
then-
back to
well,
the
then
two
there's-
situations, the choking and the infant with the slap mark, those are the two. If we
Right,
can fit
those are
those
the
into
ones
the
I can't-
definition, then I think we found a definition that works.
And
And neither of those fit in.
that's where your attempt covers that, I think. It's a
That's
matter
How
of,
can you say you're
Not
like
attempt.
attempting?
The,
attempt to choke someone. You're not successful in killing them, but you did attempt to do it.
why don't we do this? Why don't we say, as part of the definition, that there are certain things that shall be presumed by definition to impair somebody's physical condition? You're right, pain's subjective, I mean, I would argue that if the
And
kid
inflicted
wailed, if
injury
you've got a
is
witness
different?
that says, Mom went like this and the kid screamed, why is the kid screaming? Maybe shocked, but but at any rate, if we say presumptively that that choking, what else do we have?
Can I just,
Well, that's
I want to
inflicted
weigh in on the
injury.
slap, we're getting hung up on, I think, a red herring, the slapping on the face. Corporal punishment's allowed.
Not in
Unless
an
you're
infant,
gonna-
Not a baby.
not in a 6-month-old.
That's not corporal
Not in a
punishment.
6-month-old.
Yeah.
Or if you leave marks for
And
an
that's why
extended
it's here, it
period
says
of time.
less
Any
than 3 years
inflicted
of age.
injury on a baby is not corporal punishment.
Well, that's, they have here less than 3 years of age, because intellectually incapable
Where
of
does it say
understanding
any
physical
injury on a
punishment.
baby's abuse?
I think that,
Oh,
that
oh,
doesn't
I won't
say it
disagree, I
anywhere.
thought we were talking about it in the
No,
law.
I'm talking about me, I'm thinking.
I don't disagree with you.
That's where.
But then we're back to
Any
listing.
inflicted injury on a baby.
Well, here they list as under 3, so they're intellectually incapable of understanding.
This, I did, that's for that reason. Oh, okay, let's do this.
Okay.
And I'll give you a second choice. We're going to use some definition, I'm hoping it still ends up being impairment of physical condition or substantial pain, and then say that it shall be presumed where a child is concerned, and we could even break out separate presumptions for infants if we want to get that narrow in terms of defining what the tender years are, but that particular forms of conduct, choking being the most glaring, impairs the condition, the physical condition. Just, that's,
That's exactly what this is here. Functional impairment includes a fracture. If you're an infant, even if you don't walk, a fracture is it has to be included because it's irrelevant in terms of function. And that's why I think this is, we're going back to this idea that certain things, internal bleeding, whether it impairs your function or not, if it's due to abuse, it's abuse. And so it kind of goes back to the actions because you can't capture everything otherwise.
well, that's the problem. You have results, which is what you guys deal with. You can diagnose the results, hopefully in most cases, where you see the bruising, the physical evidence of it. You also have actions. You infer the action in many cases from the result. It's sort of the intellectual concept of how are we going to make what we need to do. The result isn't criminalized or isn't penalized, isn't abuse. It's the causing of it with a certain state of mind. I mean, I could just be fumble-fingered and kill a kid by dropping it, and that's horrible, but it's not child abuse. So we're going to come up with a broad definition. We're going to say that certain kinds of conduct are presumed to be abuse, to be, and I would suggest that we do it through this, that impairs the physical
And I
condition.
was
make sure that we're all on the same wavelength. Functional impairment or bone fracture, internal bleeding, what is functional impairment?
Remember, a judge said that you
No,
can't walk.
no, you brought this in
Oh,
from
functional
Louisiana or
impairment,
whatever.
you can't do an action, you're supposed, you can't feed yourself, you can't walk, you can't, and it's very, over the
Right.
age of one, once kids walk and talk and do things, it's clear what it is, but the infants, where their level of functioning is so low, that even
Yeah.
with 12 fractures, they may look totally fine and there's no obvious functional impairment, and so I think that's why they get this list, because you could have any of those without functional impairment, and they're trying to get it into the definition.
Okay.
The 24-hour thing is very
How isn't
difficult.
that
because
impairment of physical condition? Fractures?
Because if you have a fracture in your infant and you're moving the arm and you're totally fine and it hasn't interfered with anything, it's not.
See, I think we got a real distinct divide between the medical application and the legal application, because I think the law is clear. That is
No,
a
it's
physical.
not. Well, the problem is they see it as physicians, but on the judicial side, the judicial, or the DPW caseworker up in indicated land is saying, oh, no, you've got movement.
Yes.
Well, the
Right.
difference though is really, Pennsylvania says impairment of physical condition. That's your actual physical condition. It doesn't matter at what level you function, but I think you're right. I hear from doctors all the time who don't want to opine about pain, the levels of pain, because they don't want to be subject to cross-examination on that. And they're interpreting impairment of physical condition to mean impairment of how this child or baby is functioning. And this
Right.
term actually brings that to light because they're using functional impairment, not impairment of physical condition. I would say if you had 12 fractures, your physical condition is different than it was before, and it's impaired, even if you can move your arms. But whether or not you function, Pennsylvania doesn't have that function language in its definition. You know what I'm saying?
Let's give this a try. I think, Yvonne, are you comfortable with the idea that we're going to, and we can be thinking about for next time, whether every one of these results is, we're going to presume impairs a physical condition. So first of all, with regard to result, to the things you can diagnose, we're going to say, if you have any of these things happen to you, that impairs your physical condition.
The one that's hard though, Cindy, I don't know, this bruise abrasion laceration that more than 24 hours after inflicted, you're going to imagine every CPS worker tell me what time it happened, right? Because more than 24 is going to create a massive problem. So we have to somehow get away from time, just like we have to get away from age, because you can't time these things. I don't know, that's the only one that I think, I don't know how you're going to get around.
Right, well, you and I can work on
We
that.
can work on that.
We can work on that.
Can they ask a question?
So at any rate, we're agreeing that choking, fracturing a bone, causing internal bleeding, causing trauma to an organ,
Interfering with someone's breathing, poisoning a child's, all those things.
that
Right.
those are by definition impair the function of the child.
Mr.
And
Chair.
that's right.
Oh,
So
so
then
maybe
you
we
can-
Can we just keep the definition as you suggested in your motion? And have just a simple definition of presumed bodily injury and a different definition? And
Now, first of all, this model,
Or
I
the
don't think
evidence
it's worth changing it. I've always hated the idea of you do all the legislating in the definition. It's the way we've gotten to do things, but I don't think it's necessarily good. Good for you. Well, it's done enough.
That's the entire statute.
But let's give this, I've withdrawn my motion, unless you want to make a motion. I think, and that's why I think people need to have stuff in front of them to feel comfortable. But I think we've shifted we can still have sort of a simple definition, but we're going to be inclusive in terms of the stuff that everybody's concerned about in terms of behaviors and results of behaviors, we're going to presume as something that's impairing and intended to impair.
I was going to say, this gets around the other thing that we said, since we interview now at the CAC, we've had this situation multiple times where children are telling us tremendously detailed child issues being tied to beds, tied to this, and you can't do anything about it now because the action is not is not child abuse. But with this type of act, the act of tying the child to the bed for 6 hours on a daily basis becomes child abuse. And so I think it also addresses the issue when we start interviewing for physical abuse in a CAC setting. Previously, you had to have some physical finding, no matter how much people believe the story. And this allows you, the action itself, to be child abuse. And that, I think, is really important, especially if we move toward that CAC model. Because you can't interview and then tell kids we can't do anything about it. That is very abusive.
Just for purposes of clarification, I know we were going back and forth between child abuse and bodily injury, and I'm not sure in terms of what you were suggesting, is it for the bodily injury definition or for child abuse?
Well, what I was proposing essentially is that with regard to physical, in child abuse by physical injury, that's what it is. That, in other words, it's causing bodily injury with certain states of mind.
Right. Let's let Yvonne worry about that in terms of one way or another, like, because I frankly, I'm not in love with, okay, there's a whole big long definition of bodily injury out here in the definition section. Our definition of child abuse is causing bodily injury with a certain frame of mind. Well, what's bodily injury? You gotta go back here and read that.
What do you like?
I like it better altogether.
Do you want to hear Louisiana's definition? Do you want to hear?
Based on this chart.
It's based on the
Yeah,
chart. Go back to that. Let's read
I'll
it.
And they
hear it.
haven't, this hasn't been ratified yet, so it might be a little bit different.
It might be
Abuse.
Right, got it, yes.
Abuse means any one of the following acts that seriously endanger the physical, mental, or emotional health and safety of the child. And it starts with the infliction, attempted infliction, or as a result of inadequate supervision, the allowance of the infliction or attempted infliction of physical or mental injury upon the child by a parent or any other person, Okay, I was waiting for more, there's no more. Exploitation or overwork of a child, of a child by a parent or any other person. Crime against the child means the commission or attempted commission of a crime, including homicide, battery, assault, kidnapping, criminal neglect, contributing to delinquency or dependency of a minor, sale of minor children, and cruelty to juveniles.
Ours is easier. Okay.
Ours is a
But
lot
so,
easier. And then we're-
are there any lists?
and it doesn't define
This is a
physical.
proposal, this is not, he sent this to around the country saying, this is what we're doing, and there was actually a lot of comments from multiple child people around the country, so we could share some of those comments. This is
There are
not-
several states that
Right,
have
they're doing what we're doing. They have a task force to reword their child abuse law, and this is their proposal.
Oh, so that's the existing child
Right,
abuse
and this
law.
is one of their, this is their proposal for physical
Let's
abuse.
try Maryland.
Okay,
So basically, they're doing what we're doing.
Can I ask a question?
yep.
Do we need to focus on the little part of our initial definition that says attempts to cause? Like, is there, or we keep it in there, or
No.
we?
That's gotta
That-
go.
But Yvonne, I mean, that's how, it says any recent act or failure to act that is intentional or reckless and causes, attempts to cause or substantially contributes to bodily injury to a
Right.
child through unjustified force.
And what I'm gonna propose is that represents, if we stick with the definition of attempt, it would be represents a substantial step toward causing. But we've got to attempt, at least pulls in, if you risk that the court's going to do that, pulls in the specific intent to produce a result. If we're going to criminalize, if we're going to set up certain presumptions, we sort of jump right over that. So, sure, you want, well, let me ask,
Yep.
Nope, I'll be back in a sec.
Right.
Hello?
For that reason,
you want taking a substantial step towards it.
yeah, it sounds to me like the presumption idea is great, because that gives, the benefit of the doubt to the caseworkers when they have the information about the action. But I would think even more so, the attempt to cause would be an additional
Right.
But
step.
then you get into the mens rea of intent.
You do, but if you have the presumption, I think they complement each other. I don't think they're necessarily.
Okay.
Right.
I have to see, okay. So long as the presumption covers the intent part
Right.
of attempt,
Right.
I agree with you. I'm having trouble envisioning that, but you could be right. Let me, so we have at least a sense, Yvonne, I think you have a sense of where we're going. Let me pose the second question. In addition to this general sort of impairment fuzzy concept, which we then presume all kinds of specific results reflect that, do we want to also have a list of specific acts? Because if you look at this, you've got what we're capturing, as I view it, as sort of the upper part of that. And then you start talking about specific actions, not necessarily the result that is produced on the human body, but the action, beating, biting, burning, dragging. Do we want to have them enumerated separately as acts of abuse, that conduct in and of itself without regard to whether it produces an impairment of physical condition or
Dave?
substantial pain?
Massachusetts, it means the non-accidental commission of any act by a caregiver upon a child under age 18 that causes or creates a substantial risk of physical or emotional injury or constitutes sexual abuse under the laws of the Commonwealth, or any sexual contact between a caregiver and a child under the care of that individual. And then it spells out physical injury means death, fracture of a bone, subdural hematoma, burns, impairment of an organ, and any other non-trivial injury, soft tissue, swelling, or skin bruising, depending upon the factors as the child's age, circumstances under which the injury occurred, and the number and location of bruises, addiction to a drug at birth, and failure to thrive.
Well, yeah, but that's really where what Yvonne worked with already
Right.
came from. I dug that up.
I would go for strongly against doing things like listing subdural hemorrhage, and a lot of people do that, because then what if it's a subarachnoid hemorrhage, or parenchymal contusion, or
Okay.
you can't,
Let's
all
go
you can list is there's
accidental
internal
subdural.
organ, and the brain is an internal
I-
organ.
And that's, but that's not the, I'm posing a question that doesn't have to do with results. We moved on from results. Certain results we're going to, let's at least look, we're going to presume that they impaired the physical condition. I am asking whether separately, in addition to that general, in doing something that impairs physical condition or substantial pain, do we want to make abuse, because I'm not sure we covered yet the tied to the bedstead, if nothing bad happens. Do we want to include some or all of this list as that's abuse? Doesn't matter whether you do it for a minute or an hour. It doesn't matter whether there's no mark at all or the kid's hand falls off. It's abuse.
I would like to, and I propose that Yvonne, Steve, whoever, take this, put it into language, and we look at it, okay? Because
Well-
I do think this is really very nice and thorough, and we can play with some things, we can think about or take away the bruising for 24 hours, I mean, we can make some adjustments to this, but I think that this really does cover like broad ranges of things that we would want to include.
But I'm just, if you look at this and read it and think about it, we got the first part with the earlier concept, but now I'm talking about something separate, which is we're going to take other kinds of conduct without regard to what result, impact it had on the kid. We're just going to say that's abuse.
I would argue the answer has to be yes, because there are some things like shaking shaking a baby, even if the baby doesn't get a subdural, is abusive. And we have had this year alone 3 or 4 cases where people came in on other people shaking the baby, and the baby didn't have injuries, and it wasn't abuse. So I think there are certain things where the act themselves, we have to agree, is abuse. And we may not agree that all of these, I think dragging would be a tough one. A lot of parents yank their kid, and that's not every single time, but I think there are some, and shaking, I think, is one, tying kids, where I think that the act itself is abuse.
Okay,
And
well-
people may disagree on which ones, but I think there are certain ones which are.
For now, that's sufficient to be going on with. We will draft it that way and see what people think, and, we can have the vote later, but we are, it's at least in play before us that they're going to be, in terms of just physical abuse, there's going to be a broad, general, which is going to have some presumptions about what is, I think, probably impairment of physical.
Just so I understand the direction we're gonna go, there's gonna be some sort of definition that has a presumption of, that is abuse. And when you say presumption, that's rebuttable?
Yeah.
Okay. And that's, those acts, of whatever they are, will be enumerated.
Well, no, those will be the causation of a particular result, like,
Well, but Rachel's saying the mere fact of choking or shaking, for example.
that's abuse.
That's abuse, that's what I'm saying. So
Yeah.
the definition
I've got
was,
two. One that is, you produced this result, so that's child abuse. Or you've done this action, so that's child abuse.
so the definition would essentially, could envision to be Dave's definition of bodily injury, and, which is result-oriented, and a set of presumptive actions,
Right.
shaking, okay, I think that's not bad.
And I think those presumptive actions that we're talking about really help us define what is currently imminent risk.
Yeah, let's talk
Right.
about imminent risk.
Well, I agree
We
with
have
that.
to.
Can I
And that's
just follow
good. I
up
thought we
a
said
little
that's
bit
going
more
away.
on the
Yeah.
presumptive
Yeah.
Stop, I think we have to.
Well,
You
we
have
have
to
to
say
say
you don't want it.
Yeah,
Yeah.
we said we don't have that.
All right, well, hold on, Yvonne has a question she's
But
got
on
to
the
do. here.
presumptive abuse, there are in a number of states certain things that are already presumptive abuse. Some states use prenatal drug and alcohol use as presumptive. There's at least one state that says allowing your child to live with a registered sex offender is per se child abuse. So there are some of those things out there. The meth labs, if your child's living in a place where a drug laboratory is, that's per se child abuse. So there are some of those kind of things that are already out there that do you even want to consider or talk about?
If you want to list them, we can review them, but like, for example, like allowing a kid to live with a sexual abuser, I think you already have that in your definition. Like, and a failure to act that causes or contributes to the sexual abuse. So someone could
And
argue.
some of,
Well, except, does that work if the kid hasn't been, let's say that abuser never, we have no evidence.
Just living there, but hasn't actually been abused yet.
yeah, he
Well, I
hasn't
put that
touched
in
it
there.
yet.
It's,
Your new boyfriend's on the list. You have a new boyfriend, he's on the list, and he moves in with you and your kids. Is that child abuse to have him living in that same house with those kids? When he hasn't touched your kids yet, and he might have got on the list 10 years ago because of his teenage girlfriend,
Well,
but-
yeah, I mean.
I don't know, but
Well,
that's out there.
that's when you do an assessment and a safety assessment. And then you determine whether or not that child's at risk. Because you want, say you have an adult who may have raped somebody, does that mean there'll be a child sex offender? Or, and if they have a child, 20 years later, should we take their child?
Well, that was a case in Pennsylvania, wasn't it? A few
Was it?
years ago, where a guy was a registered sex offender and had a child, and he had to move out of the house because of his record, even though it was his own child living in the house. I forget where, but that was a
I'll
few
tell you
years
what.
ago.
I'll tell you what,
That's very
list
complicated.
everything you can think of in the
Oh, God,
bold
Dave
print
Christopher,
as
really
a
busy.
baby.
All these things.
And then we'll refine it.
We can talk about it.
Oh, I know.
At any rate,
We don't
we've
want
got,
to be too grandiose,
But-
Yeah.
then like, the legislature's gonna be like,
If it's
wow.
not going.
we've got a definition, or at least the next step toward a definition of child abuse to be going on with. And why don't we take an easy one before, I'm not sure when lunch comes, or if lunch is here. All right, I think that sounds like a tea whistling idea. You want to take, let's take about 10-minute break, use the facilities, grab a sandwich, something to drink, and bring it back.
Hey, I have no
Sit down.
And shoes.
And like shoes.
So you're
I was almost. We get too far away from crime stuff because
Oh, the NCAA committee submission time was formed to figure out what money. I've got one county that's giving me 7 acres.
Is that Cumberland? Yeah, they told me.
Oh, I think we're.
So, if you're at,
Yeah, it actually is going to,
You got a copy of that?
from the,
I mean, a lot of it, I don't think that is. In fact, just because.
Oh,
Let me tell you this, it fits right in.
Okay. Yeah. Fun?
yeah.
right.
No, I'll be like, and I'll judge you, and I'll talk about your
What the goal is to build this, I'm talking to some of the same attorneys, they like this.
Yeah.
Trying to second mile market, good taxes.
Whenever there's a
Restricted to this.
I think sometimes.
You had the DA's
Yeah, this is the,
Then we have, we need to make our.
We're staying, we've been, we're out of it, totally away,
stay, but,
which is fine.
this is a great compliment, nice job person. So we get 60 members. Funnel is 10% of this. The rest of the CAC, you know, them around the state, like, gas, fits this.
That's really good.
The idea is we put a module together,
Hold on to that thought. I'm thinking we can just write some
whether
of
it's
the
like
deemed
full and
as covering all situations which deemed constitute
this is how we got to find out, touch it.
Right, so they didn't.
Dumb for the federal government.
That's very cool. Good job,
I'm right,
Jason.
I just don't want
I've got to run to the restroom.
No, I hear you, I hear you.
Oh, thank you very much.
she's in the rehab part of the nursing home, like, when she passed away and stuff, but like, I sometimes have to cut through the nursing home part, and she's in charge of it. Like, I'm actually on the board of, her, so
schedule and it said 6:30.
Well, we think that it's not gonna go. Oh, the turnpike may open. Yeah.
Yeah. You'll be able to get home in a decent hour.
Especially the individuals from the.
I think we'll be,
Right.
it should be the people that are on college, like the kids that are on college campuses.
Why don't we do a video conference?
Classes there.
Oh, don't we?
I know we have the technology.
Could, I'm sorry.
Good work.
Like to have their, you know, like, we've set it up.
Physical presence is very good.
Yeah,
And I understand the stigma of teleconference, but with a video conference, we have that huge screen, you know.
And I don't think we're gonna touch volunteers.
That would give us more opportunities to actually have more meetings. Because people can't drive as far. Like at Widener, we had video conference classes where, and Dickinson too, where you start talking, the microphone turns on where you're sitting or whatever, you hold a button down, and the camera turns to your face and zooms in, and then you're projecting on the other side of the TV screen.
We've had them call in before, so one of them, all of our hearings have been at, not all, most of them have been in hearing room one of the Senate hearing room one, where they can't do that. It's only the second time we've been here.
This is only the second meeting we're talking about.
No, this is only.
Oh, anticipation.
The only second meeting where it's not public. So,
That's
you know, so,
Aren't you happy?
no, but it also, like, no comments.
No, it is.
I think, you know, everybody knows that they can call in. I don't think it's really a use conference, but we could do webinars. From here, unfortunately, from the, here.
Yeah.
So, it all depends.
I was just wondering. Is this something we had in law school? It made things really easy.
It's
a lot more.
We had to do it from the where we had the meeting.
Right.
You did too?
It's a lot more effective than just a straight teleconference.
Yeah, I don't know how really.
And there are people that just sit there and listen. Teleconference, actually. Yo, what's up, man?
Al's there, so they'll have,
Feel like
you
they're
know,
really
so they'll have some way of
That's
getting.
Yeah.
the release is done.
I know everybody loves their taste, but I can't stand it. Gotta have my meat and see them all.
Oh, my God.
Well, lunch meat is one thing. Have Bingos lunch meat.
Right.
But when you're sitting down like a dinner, you know, I don't know.
Are you a raw steak kind of guy?
I'm a raw steak kind of guy. Medium rare.
I've gotten to.
Well, it's not too bad, actually. Medium rare, it should really only be like very slightly, not slightly pink, but pink and then just a very slight red tint.
The lowest I will go is medium well.
And I do not do that with ground beef.
So they were.
I don't, I get it. Yeah.
We're not giving any product until the end of the month.
Correct. At least that's my understanding.
That's what I thought so too.
Yes.
What's that?
Just like everybody says, fly. You have a fly. Then you just go.
Wow.
It is, it's very cool.
Yeah. Where's it gonna
And I
be?
talked to Phil, well, whoever gives us the best deal.
Okay.
We're looking for like cheap and free. One of the things I want to talk to you guys about, this orientation. These two pieces right here, this is a this is not how. Training module, for a couple of reasons. One, girls. Number two, how do
My car was there last night.
That's a great idea.
This morning when I got in, I have to go get my car. So, because I got like I was in traffic right now.
And so,
Yeah,
and
that's
then,
why I saw my house. I was like,
depending on where it's located, we're gonna kind of
I was
see,
thinking
this is
literally
the
yesterday
consultant
morning,
agencies.
because I came in later than I normally do. Usually I
It's
get
also
there
a training tool
but I
for
was
us.
later. I was on the bed, and
Um,
I was thinking, oh, it's Monday morning, nobody's here. Because I was looking around, nobody ever comes down. So I was coming down at 10:30 in the morning.
This is the
Not me,
medical
hard
wing.
drive. And all of these people, I was like, I was seeing death. I was like, looking around.
Okay, go right.
You can drive it safe in the house.
5 month
And I was like, oh my god, and it was like, I was just, and there were two people, and I know that we were
Field,
talking about it. And I was like, so now I'm gonna be more conscious of like, even though I think nobody's gonna be coming down early in the morning, I will, and make sure that I get more done.
talking to some private things now, paid staff.
If you take some of those pieces from,
Really, we talked to,
I'm surprised they don't have like small
DSD people about being down, like, at the,
not at the turn, but like maybe a quarter of the way down, you know, that's odd, that's all that here.
dark.
Yeah, like you don't need them around the turn, that's like people are on slow anyways, generally. Oh, really?
There's some discussion about
I usually slow down to about 15 to 20 for the turns, how about you guys?
it's really about how much this building alone probably 3.5 acres.
Yeah, right. That's on that, that's like on the first floor there, they just painted the concrete. I don't know why they did that. It's like shellac.
I don't know. And it's, I am assistant supervisor over at all this. I'm the supervisor as of tomorrow.
And
We're gonna be there at the academy the last 3 days of October. Mini judicial training to the job. Yeah. So, who's doing it? Is Phil involved in that? Yeah, it's Phil and Jeremy, Trooper Duffy, or no, Trooper Madison, sorry, out of Fort Loudon. We have, we're in the, Greensburg, Training Center. She's doing her faculty too. I think she's probably, we just grabbed her. our faculty is.
Yeah, no,
Two or three processes.
I actually called them.
It's, why everybody's good.
Just a solicitor. We don't have any case orders yet. No reason other than
Like, I just have a nice
it's a week-long training twice a year.
Saturday, I'm not reaching my work, I have your pool, and then, they skip them all day. And then Sunday we're going to work.
Mine, Isaac, it's not gonna be like, it's just gonna be rain. Yeah.
Notwithstanding, we have
Just itch to face.
Sergeant Dustin.
Just like,
Sometimes they play with the card. That's right, what you can do.
no, because we're training on that.
It's a good, it's a great, good down, they kind of touch it, been doing this. Yeah, that's my goal, and then I'm done. I gotta back out, try to figure out, make some money. You know, working pretty hard to try to get some of that NC. We think we can get about 10 million in the right here.
That's good.
It's at 16 million of definition, right?
This is on WGA out
They used to work the liaisons.
I haven't, I had it, yeah, in New York, not in New York, kids and some of I actually went to bed.
It's a real situation where you're just like, I don't know.
Depends on
Oh, I'm always ready. Eldest of 6 times 5.
Free, oh, free.
Rod Manning,
We are all
he was with the academy.
gathered,
He's the Cumberland County DA, running for AG.
and perhaps we could go to mandatory reporters. I think it's probably the next most complex, troublesome, so say complex, nothing's troublesome, we can overcome it. Ron?
It didn't label them very well, but it'll start with section 6311. Persons regarding reports. And quite honestly, that was such a mess with the way it had been amended over time to deal with the clergy situation, when it's a perpetrator and when it's not a perpetrator, that we just basically decided to pitch it. So if you turn to page 2, we rewrote the section about who's to report child abuse. Or not the enumerated list, but the list of, on what basis do you have reasons to believe that child abuse has occurred? And then we looked at, the language had always said, a person who comes in contact with, which apparently was a problem for some people because there wasn't, you didn't necessarily see them in the office, you got a referral or a question. So we used the language, the person has a connection to the child in any of the circumstances. And we said in the course of employment, occupation, practice of profession, where you encounter the child or you're directly or indirectly responsible for the care, supervision, or guidance of the child. Or you're a person in a position of authority within an agency that is directly or indirectly responsible for the child, to try to get at those situations where maybe the bishop has heard fourthhand that a particular priest has behaved inappropriately, but would argue,
I didn't see.
I didn't see it, so, but if you know about it, if in your position, in any of these situations, under A1, if you know about it, basically you need to report it. Whether you actually spoke to the child, whether you actually saw it or not.
So that's what indirectly is.
Right.
Yeah.
Right.
I'm sure that's what you meant.
And,
Like a supervisor, even in like a case setting too.
right. And that's where A2 comes in, where we're saying the person you're suspecting doesn't have to be a perpetrator. You're going to report every case where in your position you have discovered child abuse about a child. And it doesn't matter who did it, you're going to report it. And then the privileged communications language is what was in the statute before. And that's subsection A. And then in B, again, the way it was listed, generally just bad drafting to have a laundry list, comma, 50,000 people. So the first thing we did was make it into an enumerated list. We expanded, most of the people listed above were medical practitioners, but it wasn't every single licensed medical practitioner in the Commonwealth. So we made that language on page 3 to a person licensed to practice in any health-related field. And then the medical examiner, the intern, Christian Scientist, school administrator, social worker, daycare, peace officer, those were all in the original language. And then the next 15 were ones we pulled out of the laundry list we had given you at the last meeting of potential people that we thought might be good people to be mandated reporters. Now, obviously that's open to interpretation and discussion, but one of the things we did with that was to try to bring in the coaches, the youth organizations, people who are going to have contact with children on some kind of regular basis that they would be able to determine that. And then we added, basically because a lot of other states are doing it and we thought it was a good thing to do, was the film processors and the internet service workers and providers. So I think that's a good place to stop because the next subsection talks about within the institutions, like a Penn State, and I think that's a separate issue. But on the criteria for when you report and who should do the reporting, I think that's probably, those together we can talk about.
Mary?
I'm going to imitate Cindy. Can I ask a question? If the first prong of the definition is number 1, and this is in the conjunctive, so it has to be on the basis of medical professional or other training or experience, correct? And the person has a connection to the child. If we add, and this just occurred to me last night when I was looking at this again, if we add these other, for Pennsylvania's purposes, fairly unique provisions, like Humane Society officer, commercial film, photographic print processor, and you have to have medical professional or other training or experience. As a
Why do we
basis
care
for-
about that? I'm supporting what I think you're doing. Why do we care about number 1?
I think why we were looking at that and why it was drafted originally was when you
took it from the existing law.
yeah.
I would suggest we eliminate it. If we're trying to encompass,
If we're defining
right,
who's a mandated reporter, why is that clause necessary? I just throw it out as a.
I think that goes towards how you indicate, include, but page 2.
Could I, let me just throw something out. What about reversing A and B, or it seems to me if we're enumerating who's supposed to be a mandated reporter, the logical thing to do is first just have the list of who it applies to. And I don't think, that doesn't really have to do with the substance of either section, but that just was something that's, and it's the way you follow the way the statute
We followed
has
the
been.
format that was already there, but if we're basically just repealing and replacing sections, then we can rearrange stay pretty close to the original structure of the statute, but we don't have to do that.
But I think, and then maybe it occurs more, in a more straightforward way. I'm not sure whether you need any of that language, or if you do, it would need to be clarified in some way, because, for instance, the cable man doesn't know your kid, doesn't give a hoot. You know, the cable guy, we've included because they go into houses and are going to have, you know, are liable to be seeing, in fact, I don't know, that may be a sketchy one. The film processors are, you know, we of course, nobody develops film anymore, yeah. But, we're a day late for Valley Shore.
pedophiles.
but-
Thank God for pedophiles.
Yeah, right. But I don't know, is this any use to law enforcement, guys, addressing myself to our members of law enforcement? I mean, are the cable guys, you don't get the porno channels, you know, all by themselves, I guess. I don't know what exactly they're liable to see.
I think it needs to be more geared towards, like, people who deal with people's computers, fix their computers. Because if you're saying, if I go into your house as a cable repairman and I see something going on there, I am a mandated reporter. Well, if I'm the Ehrlich's guy, and I come into your house and I see something going on, how am I not a mandated reporter? You know what I'm saying? You can't say you have to tell, but you over here
And
don't
you
have to
really
tell.
weren't trying to go for that, we were trying to go for the person who would see pornography
Yeah.
on the.
But that's what I think you're gearing more towards, like, the computer repair, someone like that, dealing with the
Right.
computer. You're not gonna get pornography over your dish network or anything like that, child pornography. You're dealing with, like, computer repairmen, some along that line.
Why don't you do in something a little bit broader, not so specific, but like in the course of, you know, employment, you come across child pornography or other examples,
Or depictions of child pornography
Something
online.
like that.
Yeah.
as opposed to trying to
Well,
list every
that's
single
much better.
Wait,
Yeah.
potential person who might find child pornography.
No.
I really think
Yeah,
we're getting
it's not
very,
just cable, man.
very broad,
You have to define it.
and we're talking about, I have two questions. In the course of employment, what about the teacher? So the first question is, what about the teacher that has noticed this kid or maybe taught the kid the year before, sees the kid at the movie theater, and the kid has a good relationship with the teacher and tells? Should the teacher have to report? And does your definition cover that?
Yeah, it does.
In the course of your employment.
Well, but she's not in her employment.
I'll tell you what, I think maybe we need to break up line here, because the whole idea of mandated reporter is we're giving you notice in advance, and we hope in most cases to even have a license to do what you do. You have to demonstrate that you completed the course, you sign your oath, you know, so that somebody who just by happenstance stumbles across this. So I think it's a nice try, but I'm thinking that probably, it just doesn't fit. Now, we could think about creating a separate duty, that if people see, because, I mean, the other thing is, you may, when you're coming in, somebody in the abstract, like the film developer or the computer repairman, comes across depictions that they believe are child pornography. You don't know whether that's of a child that lives in the house or a child that is, you know, on the West Coast and got photographed 15 years ago. So that I think it's better to have, let's hold open the idea whether we create a separate duty, maybe outside of the CPSL, maybe in the Crimes Code, somewhere, that if you're going to do these, if you're going to be in certain professions and you come across depictions that you believe to be child pornography, you've got to report them to somebody. But I don't know that it fits into the CPSL.
But we have code enforcement officers under that same, I mean, so I would suggest that it does fit, but it's how we define it.
I'd like to see the definition say, if you have this special role in the world, then you have to report no matter where you encounter the kid. So if you take off that teacher's hat at 3 o'clock in the afternoon, or you're this police officer over here, a cop's a cop's a cop. And if he sees a kid out off duty and has reasonable basis to believe that child's been a victim of sexual abuse or child abuse, that individual with that special role, because they will have special training, should have to report that a suspected abuse.
That's a different policy question than what Jackie just articulated. What Jackie and the trooper are saying is that the commercial film photographic print processor, that's archaic language. We're going to address people who are responding for information technology upgrades or repairs in homes who come across pornography on a person's computer. That's somebody we want to know in their head, this is my profession and I have a duty to report,
Correct.
right? So
And who are they reporting?
if they're mandated reporters, they're mandated
I
reporters.
still have concerns if you're getting really, we're going to go real close to having everybody in the world being a mandated reporter. We know it doesn't work. We can't even get the people that are supposed to be mandated reporters now to report who are supposedly having training. So I think, you're going to get Comcast and everybody else to train all their tech guys.
Right.
I think we have to be really careful to go down that road where,
And to be honest, people who do come across child pornography, like they often do report, right? Like somebody
Yeah,
does
we
on
do.
the computer, there's a guy who
Yeah.
comes across something, or somebody at work comes across
Right.
somebody's child
A lot of
pornography.
it's in their policy that they
They have
yeah.
But I think maybe taking it out of a professional contact, that gets really difficult.
Yeah,
Say I have a friend, one of
Separate
my
issue.
friends
Hold
works
on,
up there.
hold on, separate
Okay,
issue.
I know,
You're right.
Jason Drucker, that's
Okay.
a huge.
I'm sorry, I'm doing the best I can. So,
One sandwich at a time.
how many, let's see the hands for those who believe that we should at least consider adding to the list or keeping on the list people like the Ehrlich man, like the film processor, who are not going to have direct contact with the kids, who are not, we are simply identifying them by the fact that they may be in the home, or incidentally to the well-being of the child. How many want to include those?
Well,
I don't think that's what he was suggesting.
I wasn't
think he was-
saying that.
I think he was pointing out that the way it's written, you would naturally think that all those other people should be included. I think what he was saying is we want to categorize it to be the IT people, the people who are going to be working on the computer,
Right.
the people who
Yeah,
are
right.
having,
Exactly.
right, your cable guy is not necessarily going to
Well,
tell you how
okay,
to.
early guy, we're the early guy.
there's no sympathy, or there's no, whatever, interest in having the incidental people, house painters, who look in windows aren't gonna be,
We're not gonna be
okay.
able to train them.
Now,
Right.
how about people who, and I guess it would be mostly computer repair? We don't license those people in any way that I can think of.
But we
So-
don't license municipal code officers either. We don't license.
Employed by the,
We don't license.
Well,
Coachella.
well, wait, whoa, actually,
I think you.
I would have, I'll tell you what, let's just go down this.
See, that's two categories. We're really talking about people who are going to be in the home. And then the second category is people who just by their profession are going to come in to access with potential child pornography, which I think is,
Different.
yeah,
Yes.
separate issue.
All right, how about, let's see a show of hands. How many think municipal code enforcement officers should be mandated reporters?
I don't know what those are.
Wait a minute.
They're like the zoning inspector or building inspector.
The grass is too high.
Red tag a house.
I don't-
We had that problem.
I don't want to say they shouldn't be, I just don't know that they need to be in an enumerated list. I mean, it
Well-
says in the scope of your employment.
We're gonna give, we haven't, I'll tell you what,
Well, do those people
let's
come
back up.
across- Do they work with children? That's like my thing.
No. No, that's the point. There are a certain number of people on this list who are there, I infer, because they go in and out of your house. They're liable to stumble across things that, like scurry magazines or whatever, just because they're rooting around looking for roaches in your closet or something.
Yeah,
Yeah, but-
right.
So,
They're gonna be one
I agree with
fine
Cindy.
or severe neglect.
Yeah, they're gonna
Yeah,
be
they
like-
are.
child.
They're gonna be the people that go out
And
to
you
register
would
the
think
house
they
that's
would-
condemned, and they find a kid chained to a radiator in a back bedroom that hasn't seen the daylight for 3 years.
Okay, so
That's,
do they
And-
not report those?
Well, that's the
We
issue.
don't know.
We
We'll never
want
know.
them to
We
be
know
a
what we- some do,
mandated
yeah.
reporter. I'll tell you what, another way, I would propose that we don't want to make mandated reporters of those who are simply likely to stumble across this stuff because they go into your house. Any strong disagreement with that? Okay, so that takes care of the municipal code enforcement officer, the humane society officer. Now, the other category is, and I think it takes care of the repair, the last X, your phone man or internet man. I think a separate issue is raised with regard to the film processor, and now we're moving into modern times and saying the computer repair person. Let's hear some discussion. Does somebody want to move that they should be mandated?
Yeah, I suggest that they should be.
Okay. The question that arises, and I don't know that I disagree with you, they don't get registered with anybody necessarily. How are we going to let them know that they're required to be trained? How are we going to let them know that they have the obligation? Because really, we hope every right-minded citizen sees Kitty born and they're going to say something to the local police or somebody. The issue with this is we're creating a statute that prosecutors are going to prosecute under. And I'm wondering how successful we're going to be with that.
Let me throw this out there. In July 2009, the governor signed, and it became effective, the Home Improvement Consumer Protection Act, which required those that do remodeling on homes to be licensed, get a HIPAA number, required their contracts to be in writing, blah, 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 blah. Maybe we could suggest those, if you want to work on computers, you have to get a computer number and be registered. Then you know.
Big government. In the next week of the Republican convention.
Home Improvement Act, it took like 6 years to get that thing passed because of the resistance to that kind of infrastructure.
Well, the other thing, there are people that just do it on the side all
Right,
the time
lots.
anyway, lots and lots of people. It's just like a part-time thing they do at home. I mean, that's who does my computer repair.
But you do it at your own, that's their choice, and if it's their choice to mess with your computer and they stumble across child pornography, they should be telling somebody about
Well, I
that.
agree, but we're
And
talking
so-
about licensing.
so-
You're not
well,
gonna be able to
all right,
license
so-
all of those people.
Well, and
I've
here's-
walked away from that notion, but I don't want to walk away from the notion they should be required to report.
Are we required to even tell, why do we have to train everybody about everything that's in the crimes code, or, if that,
Well, you've got, by virtue of your business, you've got a specific obligation. In other words, the only real relevance to this, other than just advertising to people that it's a good idea, is that you can actually find evidence in a particular case that there was this child porn and that this guy didn't report it, and then you're going to bring that to a DA to prosecute. I think that's
well, I don't
going to
sit
be
there and
tough.
read a crimes code to every citizen that would end up going out and arresting them, because they should probably know that they shouldn't be doing something that would cause it, you know what I mean?
Yeah, but an awful lot of the crimes code relates to the Ten Commandments loosely at any rate, aside from drugs.
I don't know,
I don't know
let me
about
pop them open and I'll.
One thing I think that I see in my private practice, not so much from the DA's office, is I have good people who call me and they're concerned about liability. And my only concern is if we don't include, and I'm just throwing this out for discussion, but if we don't include those people who we presume will have contact with child pornography, and we don't give them the immunity to report it, they're gonna be concerned about liability on turning something over
Yeah, that is.
without having something, and that's why when you look at a lot of the laws that are written about reporting, it's always followed up with an immunity section, if it's done in good faith, that there is no liability, and so you're gonna have people who are just blue-collar, salt-of-the-earth folks who are trying to do something to make a living, and they're gonna be torn about, what they're seeing and whether or not it questionable images, and are we not
Little
providing
kids
them
in
enough?
the bathtub. and-
Well, we're not providing them enough direction, and are we giving them protection?
I'll tell you what, I think that's an excellent point, and I would suggest the following. We take some of those people we've already counted out, like for all I care, the house painter, the Comcast guy, and everybody, have a section that gives them immunity. If they report, which certainly should suggest that we want them to report, that that's an appropriate activity.
Yeah.
Well, but
But
for
we don't
reporters,
enumerate them as mandated
For
reporters.
what? No, it's for both now.
It
Was,
was-
it
For
used to
everybody?
be- Yeah, it used to be only mandated reporters had it, the good faith immunity, but it
Okay.
was amended
so it's
the
not
other
necessary.
year that it was for, persons who just made the report also.
Okay,
It's because it says now in 6318A that a person, hospital, institution that participates in good faith in making a report, whether required or not. So a person, whether required or not. We get to
well,
anybody.
then presumably that answers that part of it. I just have a tough time if we're creating this rubric, and especially that what we're trying to do is up substantially the report, the education obligation. I hate to leave people in there that we can't effectively reach out to and educate.
Especially if you're gonna make it
Trooper.
a higher crime, not
Right.
Thinking
That's
thinking
what I
about,
think too.
Right.
thinking about mandated reporters for 20-some odd years, I always thought they were the persons who have care, custody, and control of the child. Bottom line, and that's what it should be. It should be, and that's who everybody here, take out the guy who develops who works on the computer. That's what everybody else is. They have, at some point in their career, they're supervising a child. They have care, custody, and control of the child at some point in time. That can be enumerated just like there is in crimes code. If you're a doctor and you don't report a gunshot wound, you know, we can come and get you. I know, in the section where we talk about child pornography in the crimes code, it can have in there something about if you are working on a computer or something like that, you find depictions of child pornography, you shall report them, you know, and if not, you're subject to whatever. But that's something different than this. I thought this was care, custody, and control. They're mandated reporters.
You may want to include librarians.
Yeah.
I didn't see librarians on there. And they
What-
do supervise children and they.
Librarians, apart from those who are employed by the school, we've got all school employees, but yeah, you're right, community library, okay? Good. Could I raise an issue, so we're okay, well, I don't know, Jason, I guess you've got a motion on the floor. Do you persist in wanting anybody who isn't involved in care, custody, and control to be a mandated reporter?
I want to, those that have a special role or job or relationship, that you can't claim your mandate reporter requirements expire when you stop working that day.
Oh, okay, that's a separate issue.
That's my.
Okay, we'll definitely get to that. So,
Care,
we're not,
custody, and control works until you get into the bishop or the supervisor 4 levels.
but that's okay, that's chain of command. They're at least a part of an organization that is in some way responsible for the care, custody, control of the kid. So we're good with that particular policy decision. Let me raise, if I, just while I think of it, we've, for the sake of simplicity in drafting, we've now got everybody who's licensed in a health-related field. And I'm just wondering, when we get around, the legislature gets around to chewing on this, a bunch of different technicians, for instance, the people who, and there's more and more different machines that do stuff.
Radiology technician.
Yeah. Is that an additional burden, an additional cost on health care that really, they're not very likely to encounter this?
The latest additions this year were genetic counselors and something more with professional athletic trainers. But,
Yeah, well, that's,
you know,
okay.
was just trying, because they did such a laundry list with the LPNs and the podiatrists and everybody else, they were trying to encompass every healthcare professional they could think of. And so I think that's why those were all thrown in there. And for me, I didn't fold it into the licensed health-related field because some of those, I guess some of those clinical personnel wouldn't be licensed, but do you want a receptionist at the clinic to be a mandated
I
reporter?
think, well, I have a question about number one still, but under number three, I think if you just said any hospital personnel engaged in the admission, examination, care, or treatment of individuals.
Well, I mean,
But you have
that
to
was
be
saying that
hospital.
medical facility
Yeah.
versus hospital.
Or what are the types of facilities
medical
licensed by the
provider.
Department of Health? Right?
Can we just say medical provider? Would that be
Mary's
broad enough to
suggestions
include a
are good.
doctor's
Yeah.
office as well as
You
a
could say maybe healthcare provider.
healthcare
Yeah.
provider?
Mary,
Because we really kind of want the doctor's office
I think you're,
receptionist to,
Well, then that's not gonna be a person licensed to practice, so what Mary's saying about
Why?
anybody who
That's
works
what I'm
at.
saying.
No, but you're under number three, it would be
Well,
healthcare
institutions
provider,
license,
personnel engaged in administration or admission, examination, care, or treatment, that would cover the receptionist
Honestly,
who's
why would a
watching the interaction
receptionist-
in the waiting room.
Why would how would a receptionist ever see abuse?
Oh my God, oh my God.
In
No,
the
a
waiting
parent
room.
yelling at a child is not abuse.
well, but that's
Yeah,
not
that would
abuse.
be.
You come in and I take my niece in and I walk in and say, she's got evidence, I believe, of sexual injuries, babysitting. They walk in, they triage the kid. and-
Not the receptionist, they're a
Actually-
non-medical person.
We had a case where.
What about the janitor?
Where
We
there
want
was,
it.
there was a receptionist in the doctor's office.
What about the
We didn't
janitor,
say,
Rachel?
We don't want them, you want them, you can have them, like,
yeah.
those kinds of things.
That's what occurs to me, that may be, in a particular case, as far as somebody gets. Kid comes in bleeding copiously out the ear, and no doctor's there right now. She's, well, like,
But is that likely abuse? I guess you have a completely.
What if it is, though?
There's no training that receptionist has that makes them.
What about the janitor, the Sandusky janitor?
Thank you.
We're trying to get all these people in there.
I think that was your idea.
well,
Are people not gonna wanna take jobs, certain jobs, because there's this huge reporting requirement that they don't?
well, that may be daunting if they really think about it, but I don't see why. I mean,
Why is this-
Florida, yeah,
why is this
hold on a second. Florida, everybody's a mandated reporter, so it's just not that big an obligation. And there's gonna have to be some training sets here. I mean, I think I've related, I'm now on the board, how that happened, I don't know, since I was never a Boy Scout, on the Boy Scout board. And, you know, once I learned how to work the computer, it took me maybe 15 minutes to go through the good touch, bad touch, whatever the heck it was, and answer enough questions right that they said, okay, bless you, you could be a Boy Scout sucker and give us money. You know, end of story.
Yeah, but don't be.
Yeah, well, that's, I hear you.
We have, but Rachel, for example, in school, the school secretary is a mandatory, mandated,
So maybe it's not.
right? So she's sitting in the lobby, just like a receptionist is sitting in the lobby of a physician's office. I think we need to clarify,
So I guess the wording just needs to make.
Yeah,
They don't
we
have
can
any
fine
special training or experience that somebody else may not.
right,
That's
we're
what I'm
talking
saying
about
with the
taking,
training.
getting rid of the first prong of that test, right? So just simply by virtue of what you do.
We'll take it out.
Then the other issue is, we've got the medical facilities that are licensed by the Department of Health that aren't hospitals, right? You have something lesser than hospitals that are licensed, and then you have doctor's offices.
Yeah, I think Cindy recommended healthcare provider.
I almost did number three, to say healthcare provider or any hospital personnel, that, like, include both of them, like, just make it broad, because basically it's what you're trying to get at.
So then that would include healthcare clinics for like ST treatment on college campuses and stuff.
Oh, well, maybe we could work with you in terms of identifying what those common phrases are in DPW and health world, like healthcare clinic, you know what I mean? If there's a string, a laundry list that are typically used in your regulatory world, that might be helpful to people who are actually in the field, so they know we're talking to them about
And
training
I
their
don't know what
people.
the, I don't know
But,
what the phrases are.
yeah, that would help us.
Yeah.
So we have a sense, policy-wise,
Right.
my concerns notwithstanding, pretty much anybody who's standing around the medical profession in any way, shape, or form is going to get
Contact
training.
now with who is, yeah, right. But I'm still a little worried about number one, because I'm not exactly sure who is licensed and who isn't licensed. And
Well, you're afraid we're going to lose people because they're not licensed who should be
But then you
incorporated?
capture them free.
okay.
Get three
Any
cents.
personnel free, you got capture.
Jason has been very patient.
I'd like to suggest that anyone that is licensed by the Commonwealth, has the privilege of working as a licensed individual in the Commonwealth, should be a mandated reporter.
For anything.
Anything?
Yes.
Like a license in plumber?
Lawyers?
Yes. Licensed. So the Bureau of Professional Licensing.
In behalf of 400 and some
Hairdresser?
legislators, I will certainly second that, so long as your phone number at home is attached to that requirement.
Put it on there.
So
If
that,
that's what it takes, put it on there.
Any discussion on that?
What % of Pennsylvania citizens would meet that requirement? Because if you said it was 60%, then I said, well, then now it's universal reporting, right? Once you hit over,
It's
so,
not 60.
no, I don't know, what % meet any of those, any licenses? I mean, you're a hairdresser, all these people are licensed, aren't they? All these things.
Yeah.
So what % of people hold some?
Cut a little kid's hair.
Well, you've got to
evidence
be a
of
little
abuse.
careful. I mean, truck drivers, for instance, have to have a special license.
Yeah, well, not drivers.
Not drivers.
Professional licensure.
There are licensure boards all over the place in
Also,
labor,
does that mean that you can't get
and,
licenses if you're
agriculture.
I'll tell you what, this, we may be able to narrow that by getting to the other issue that I think that Jason advocates on, that I think we may have some disagreement. Let me, however, raise one other question of a simpler nature about the list. We have school administrator here. Now, you have, in the definition section, you've now expanded school to include secondary, presumably colleges and universities. Is there some drafting reason we can't say colleges and universities? I thought it was secondary. Oh, do you?
Can I just go back before?
Well, I promise, I'll double back to you. Let's just get that, because the problem is we get these things out there and then we never get them.
In the draft on the school employees, we redefined school, elementary, secondary, post-secondary, every public, non-public, private, and parochial school, including each of the following, anything under Department of Ed, state-related and state-owned colleges and universities, community colleges, both tax units, charter or regional charter schools, private academic schools, nonprofit schools. So we pulled that list out.
Right, and I guess, just for simple-mindedness, throwing in college, is there a reason? You may well capture those, and education is not something I ever.
I think the problem, it's not a problem. I think the convention in the Public School Code of 1949 and its accompanying statutes is to refer to colleges and universities as secondary education. So I think it's a term of art that gets thrown around. It's in the state school employees retirement code. It's in the public school code. It's just kind of a ubiquitous term that replaces colleges and universities. If we want to call them that anyway, we can, but secondary seems to be the term of art.
Well, but
If
doesn't
we
that also
say-
include community colleges and trade?
Oh, no, they got all those, and will it hurt anything to be duplicitous or duplicative? Hey, I was in the legislature for more than 10 years, I am duplicitous. Oh, thank you.
I mean, we could say
So,
any
just
public
if we
or
stick in
private.
colleges and universities, then everybody can say, yes, we got Penn State, it's understood.
All right, yeah, we can play
Okay,
with that.
That's just
It's in
a
our
little one.
Okay.
I think, Jason, we're going to double back on the same policy issue. You raised it a little bit ago, I think Dr. Berger started to speak to it. For the people we all agree should be listed, the social worker, the daycare center worker, the peace officer, the lawyer. Do we include lawyers here, right?
No.
Now, I think lawyers probably ought to be. I
Well,
think it is.
the problem is if you're a criminal defense lawyer defending an alleged person,
Well,
and
but
they
then-
make it a mission.
But we have
There's an
privilege.
exemption.
We have a privilege
Yeah.
for, clergy, I think,
Well,
a lawyer.
let's, okay, I'm a law enforcement officer.
Well,
I
then you go
see
to
the kid in the grocery store who's, maybe they're being abused, maybe they're not. Do we want the people we absolutely agree are mandated reporters because they have a care, custody, and control one way or another of children in their professional role? Do we want to put the reporter obligation on them in the grocery store? If they see something going on, if they're at home, look out the back window and see something going on next door. So that they are so I can prosecute them if it happens in Bucks County. We can prove that they saw a little kid, mom drowning a little kid a bit, comes up sputtering, how'd you like that, down in the water again. We can prove I saw it, I don't call in. Do we want
Yes.
them, and Jason would argue in favor of that? Doctor, I think you're to the contrary?
I think that once you start doing that, you're universal, you're asking people outside of the context of their work. And this has always been, you can't have every janitor and if every single person in a school, maybe a doctor and a police officer is different because I carry my job home with me. But the vast majority of people that you're talking about don't, quote, carry their job home with them. But you know what I'm saying? Like, people in the community know I'm a doctor, and they'll come up and say, yeah, look at my kid's ears. So it's a different issue.
$50. But the idea is, we've
It's
trained,
different than a
they've gotten
janitor
there.
at home.
But they will have received the mandatory reporting training. They've learned it. They walk out the door. They still have that training and knowledge. Why
But you're
don't they-
taking out the training and knowledge part.
But they
We're
also
taking
Okay,
out
well,
information.
we have, hold on. Allow them.
That's exactly what I want to say. If I'm a mandated reporter and I'm going to the grocery store, what am I supposed to say? Hold on, woman, you're beating your child. I want your name, your phone number, whatever. You can't do that. I may see it and go, you know what I'm saying, and that person walks out the
You
door.
call 911.
711, I suspected.
Oh, in that situation, you call 911.
You call 911, but I think there again, it's got to be under what it says, the care custody.
Doctor,
So I would think that most of us in our lives, we're not walking around our neighborhoods in our, in our non-professional hats, seeing child abuse left and right, okay? It's not like I'm a school teacher and I'm at the grocery store and every day I'm seeing children who are really being abused. Every once in a blue moon you might see something. And if you're a mandated reporter and you're aware of your mandate and you see something horrific, you would likely pick up the phone or do something if it's really outrageous, okay? But I don't know, again, that we can mandate everything, right? At some level, we can't mandate like morality. We can't mandate everything. So, I don't think we should have everyone as a mandated reporter. So I think we have to be precise about kind of the situations where we really mandate that report, and then leave it to the goodwill of people who see occasional terrible things to do the right thing.
And also, David's point about the political ramifications in terms of application to everybody who's licensed, even this narrower field, with regard to now saying to all physicians, everybody who we are now identifying, your mandatory reporter 24/7, creates a political problem for whoever the prime sponsors of this legislation are. Because all of those professional associations are going to have great difficulty, PSEA included, with a 24-hour requirement.
I gotta tell you, I hope it's taped, I don't care, okay? This is about protecting kids, and I know this is your job, and you're focused on that, with all due respect, I don't care. This is about stopping the nonsense that happened at Penn State, stopping the nonsense that happened with the clergy down in Philadelphia, enough's enough, we have to do the right thing, and the right thing is to protect kids that are victimized.
Nobody
Except-
disagrees with that. Nobody here disagrees with that.
Except that I think it's fair to say that if your position goes down, if we restrict the obligation, the penalties for mandated reporters being subject to prosecution to their professional duties, both the people who should have spoken up at Penn State and the people who should have reported within the clergy in Philadelphia would still be prosecutable. So that, well, unless there's further discussion.
There are cases that are lost before the appellate courts at DPW did the administrative process where the hairs are split on who's custodian, what role they're in, that sort of thing. And cases are lost because of those definitions, care and custody and that sort of thing. And the definition is, it has the kid come before me or not.
And that's a terrible piece of wording which we're getting rid of. I mean, we've already, I think you've all noted that Yvonne, perhaps the greatest blow we could strike today, got struck by putting some brackets in and all that crap about school and a whole separate system for school, gone, concept. We don't have to discuss that because it's just some brackets and it's gone. At least that's what we recommend.
What I don't understand is, we have a kid that goes to the movie and sees the teacher who they trust. They had a good relationship with a particular teacher. Might not be the teacher that's our homeroom teacher today, but a teacher from last year, and feels comfortable telling that teacher, we're going to say it's okay for that teacher, doesn't have to report a known child abuse.
But you come back to the point Delilah raised. Because your definition of abuse also includes severe neglect. Am I gonna go to the grocery store and I see some kid looking bedraggled? Am I required somehow to report that I think that child has been abused because he looks like he's been severely
Well, that's not-
neglected? And what do I report? I don't know who it is, I don't know where they live, I don't know what the circumstances are. I mean, what are you reporting? I saw a kid who looked like he was in trouble at the Giant in
Call the
Middletown.
police.
You call the police.
But how long is it gonna take them to get there? The family's packed up and they're gone.
Well,
and
sure,
they
I mean,
know
that's
what's
not
going on.
Well,
But to
you
call
get
a
the
child line
license
is not
number.
practical
I'll
with
tell you
information.
what, yes.
You
Kathy?
follow, you follow them to the car, you get their license plate, you call child line, report what you saw, and then we go figure out where they live.
But I don't.
We're making excuses about not being able to find the kid or not the purpose. The idea is, let's get an investigation going.
But not mandated.
All right,
Vote.
we okay?
John said.
Oh, John?
Friends of ours had their 4-year-old fall down the stairs. The 4-year-old fell down the stairs and had a big black eye. It was horrible. It looked horrible. They took her to the emergency room, of course, like it happened, like any parent would. And the doctor talked to the child, and they actually said, the doctor said, the little girl said, I fell down the stairs. The doctor said, how many stairs? And she said, all of them. She fell down from the top and everything. So they got the child treated. But this kid had a big black eye. So, okay, so if they're in the grocery store or wherever, is somebody, should we be involving the Children and Youth Agency in their life now?
We're making all these hypothetical situations to get out of doing this thing. It's reasonable basis to suspect abuse. If you're saying the person in the store doesn't have enough information to formulate that idea, you don't have to report.
That's not how they're gonna say, you have to report it wherever you are. They're gonna say, I saw a kid with a big black eye.
You have to report a reasonable suspicion that abuse has occurred.
You're saying that
And
your
how do you get
obligation
that
should not end with a time clock.
That's right.
And I agree, I'm not on the clock, okay? 24 hours a day, I'm responsible for 500 and some kids.
Right.
It's not between 8:30 and 4:30. And I know it's difficult, but I mean, those are situations, I'm a mandated reporter, period.
Right.
Period.
But,
And does it stop at the end of the clock?
well, you've got an argument that you're, I think by reason of being in charge in an administrative position, you may be on duty 24 hours a day, at least with regard to anything that would come to your notice, kind of because you're always on. But do you want to be responsible? And again, the grocery store is kind of a bad. But you see the thing that I wonder about is when it is hard to come up with a hypothetical, other than the teacher who by virtue of his former relationship to the child gets trusted, and maybe we could carve out an exception for that. But just the fact that you've been trained for this, say you see somebody beating the crap out of a 4 or 5-year-old out in the parking lot, I mean just wailing away, you're gonna call 911 because that's a crime being committed.
Right.
Do we want you to have a special responsibility by virtue of your involvement in the educational establishment to make that call?
Yes.
Call the police.
And I can
And if
prosecute
you call the
for that.
police and if you don't call Childline, you could be charged.
No, that's report.
I
That's a
mean,
report.
Well, but
the
not
one
in-
that's-
no,
There's no
mandate
DA
reporters-
prosecuting that.
Yeah,
I-
that's never gonna happen.
But like you're
Realistically,
saying, this
even
could
if we.
happen.
Yeah.
Just say, here's actually, a couple weeks ago, I was in the grocery store. There was a mother who was screaming at this little